Okay, welcome and thanks very much for coming this afternoon to our annual observance of Constitution Day. Constitution Day is a day that's been set aside by the United States Congress for the commemoration of the proposal of the Constitution in 1787. The actual date is September 17th, which is when the members of the Constitutional Convention signed the Constitution. So we're running a few weeks late, but don't tell anyone. And I think Congress has its hands full with other matters at the moment, so they're not likely to notice. I want to begin by expressing our deep gratitude for the support of the Jack Miller Center for Teaching America's Founding Principles and History, as well as to our co-sponsoring institutions, the Chicago-Kent Institute for the Supreme Court of the United States, or ISCOTUS, the Chicago-Kent Lambdas, and the law school's chapters of the American Constitution Society and the Federalist Society. I want to invite you to reception in the lobby following this event, and I also want to let you know about another treat that we have in store, which is that Chicago-Kent is currently hosting the debut of an art exhibition that's designed to raise awareness of human rights violations around the world and to help end them. The exhibit is entitled The Art of Influence, Breaking Criminal Traditions. It's located up on the third floor, and so after this afternoon's forum, we encourage you to come out to the lobby and enjoy the reception, and then if you're interested, to head up to the third floor and to look at the art exhibition. We thought that there was no better way to celebrate Constitution Day this year than to look at two recent Supreme Court decisions that confronted one of the most important as well as controversial issues in American constitutional law right now, and that is, in general, the rights of gay and lesbian Americans, and more specifically, whether the Constitution protects a right to same-sex marriage. And what I want to do is just to take a few minutes to briefly sketch the background of the two cases that we're going to talk about, and then introduce to you our three speakers, Professors Katharine Baker and Carolyn Shapiro of our faculty, and Professor Elias Sohn of George Mason University Law School. So the first case, or one of the two cases we're going to talk about today, is Hollingsworth against Perry, and it began in some sense with a California Supreme Court decision in March of 2008 that held that the right to same-sex marriage was guaranteed by the state constitution in California. And there was actually a period of a few months when marriage licenses were being issued to same-sex couples in California pursuant to the state court decision, but opponents of same-sex marriage in California supported a ballot initiative called Proposition 8 to overturn the decision of the state Supreme Court. Prop 8 proposed to amend the state constitution to provide that only marriage between a man and a woman is valid or recognized in California. And that was a hotly contested ballot initiative, and it passed in November 2008 with just about 52% of the vote. Two same-sex couples, Kristen Perry and Sandra Steer, and Paul Katami and Jeffrey Zerillo, then filed a lawsuit in federal district court in California challenging the constitutionality of Prop 8. And they were represented by the so-called Dream Team, David Boies and Ted Olson, who had been opposing counsel in Bush against Gore, Boies representing the Gore campaign and Olson the Bush campaign, but who, sort of a leading Democratic and a leading Republican lawyer who teamed up to bring this lawsuit in California, arguing for same-sex marriage. The district court held extensive hearings and took testimony, and then issued a broad ruling striking down Prop 8 as a denial of equal protection and also a violation of the fundamental constitutional right to marry. At that point, Governor Jerry Brown and his Attorney General, who were both Democrats, declined to appeal the district court decision. And it looked as though the litigation might be over, but the supporters of Prop 8, the official group that had sponsored the initiative, then sought to bring an appeal on their own behalf to the U.S. Court of Appeals for the Ninth Circuit. And that court divided 2-1 and upheld the district court decision, but on narrower grounds. What the Ninth Circuit said is that once California had granted same-sex couples a right to marry, the state couldn't take that right away without having a good reason. And the court didn't think that a good reason had been shown. The supporters of Prop 8 then appealed to the United States Supreme Court, and this, I think it's fair to say, was one of the most closely watched decisions of last term, or indeed of the last several decades, because it presented the question of whether the United States Constitution guarantees a right to same-sex marriage. The decision came down at the end of last June, but anyone who was looking for a decision on the merits about whether there is a federal constitutional right for same-sex couples to marry were disappointed, because the court decided that the proponents of the initiative didn't have standing to appeal the case to the Ninth Circuit or to the Supreme Court. What the court said is that only the state itself or the state officials had standing to represent the state and to appeal the case. The vote was 5-4. You can't tell the players without a scorecard, so we made up a handout that tells you sort of who was on what side of the case. And the majority opinion in Hollingsworth was written by Chief Justice Roberts. He was joined by Justices Scalia, Ginsburg, Breyer, and Kagan, which is not a lineup that you see very often. And on the other side, you had an equally unusual lineup of Justice Kennedy dissenting, joined by Justices Thomas, Alito, and Sotomayor. And they argued that there was standing, and so the court should have reached the merits of the case. So in this way, the court declined to reach the ultimate issue of whether the federal Constitution guarantees a right to marry, but the decision did have a very important practical impact, which is the effect of the Supreme Court decision was to reinstate the district court's decision and so effectively legalize same-sex marriage in California, which is the most populous state in the Union. While the court avoided the merits in Hollingsworth, it did address them in the second case, United States against Windsor. Edith Windsor and Thea Spire met in New York City in 1963. They began a relationship that lasted over 40 years. And if you saw The New Yorker about last week, I think there was a big story about their relationship, which was actually pretty racy. In 2007, after they had been together for over 40 years, they went to Ontario to get married, because at that point, New York did not recognize same-sex marriage. They then returned to their home in New York, and Spire died 2 years later in 2009. And when she did, she left her entire estate to Edie Windsor. Windsor then sought to claim the estate tax exemption for surviving spouses under the Internal Revenue Code. But she wasn't allowed to do that because of a federal law called the Defense of Marriage Act, which was passed in 1996 by a Republican Congress and signed by President Bill Clinton. Section 3 of DOMA provides that under federal law, the word marriage means only a legal union between one man and one woman as husband and wife. And the effect of this law was that the federal government would not recognize a marriage between two men or two women, even if the state where they lived considered them to be married. Windsor had inherited a very substantial estate, and so she actually owed over $363,000 to the IRS in estate taxes, which she would not have owed if the marriage had been recognized as being lawful. And she paid the taxes and then filed suit, challenging the constitutionality of DOMA. The district court and the Second Circuit both ruled in her favor, and the case was then appealed up to the United States Supreme Court. And once again, the vote was 5-4, but with a different lineup of the justices. Justice Kennedy wrote the majority opinion. He held that DOMA violates the liberty and equality guaranteed by the Fifth Amendment. He wrote that DOMA undermines the public and private significance of same-sex marriages that are valid under state law, for it tells those couples and all the world that their otherwise valid marriages are unworthy of federal recognition. This, he said, places same-sex couples in an unstable position of being in a second-tier marriage. The differentiation demeans the couple, whose moral and sexual choices the Constitution protects, and there with a citation to Lawrence against Texas, which he had written 10 years earlier, striking down sodomy laws, and whose relationship the state has sought to dignify. And it humiliates tens of thousands of children now being raised by same-sex marriages. There were 4 dissenters, Chief Justice Roberts and Justices Scalia, Thomas, and Alito, and they wrote 3 separate dissenting opinions. Justice Scalia argued that to defend traditional marriage is not to condemn, demean, or humiliate those who would prefer other arrangements. Justice Alito said that Windsor is really seeking to have the court resolve a debate between 2 competing views of marriage, and that that's something that should be decided by the people of each state or by their elected representatives rather than by the federal courts. And Chief Justice Roberts agreed with those sentiments, and he also wrote to stress that the court in Windsor did not decide whether states must recognize same-sex marriage, but simply had decided that if a state did, then the federal government would also have to. The impact of the decision on the federal government was basically to open up all the rights and responsibilities of marriage to same-sex couples who have marriages that are valid in the state where they live. So the Obama administration has been seeking to implement the law by revising the implementation of over 1,000 different federal statutes that provide rights or impose responsibilities on married couples. As you know, there's also a great deal of legislative action in various states and some referenda in different states. At present, same-sex marriage is recognized in 13 states and the District of Columbia. There's a strong push for same-sex marriage that's currently being made in the Illinois General Assembly. With that background, let me now introduce to you our 3 distinguished panelists today. Ilya Somin is a professor of law at George Mason University School of Law in Arlington, Virginia. His research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. He's the author of a book that just came out entitled Democracy and Political Ignorance, Why Smaller Government is Better, published by, excuse me? Smarter is smarter. Not necessarily better, but smarter. Published by the Stanford University Press. And he has another book that he co-authored, which is coming out next month, called Conspiracy Against Obamacare, The Volokh Conspiracy, which is a blog that he often writes for, and the Healthcare Case, which is going to be published by Palgrave Macmillan. Professor Carolyn Shapiro is a member of the Chicago-Kent faculty. She's the director of iSCOTUS. Her scholarship is largely focused on the Supreme Court, its relationship to other courts, and its role in constitutional democracy, as well as employment law. Together with Professor Christopher Schmidt, she recently organized and edited a Chicago Law Review symposium on the Supreme Court and the American public, which was just a wonderful event that was held about a year ago. Her other recent publications include Claiming Neutrality and Confessing Subjectivity in the Supreme Court Confirmation Hearings, and A Progressive Contraction of Jurisdiction, The Making of the Modern Supreme Court. Professor Katharine Baker is also a member of our faculty. Much of her recent work focuses on family law issues. She's written numerous articles on the legal, cultural, and biological constructions of parenthood, marriage, and family, including recent articles in the Ohio State Law Journal and the Journal of Law and Family Studies. Most relevant to today's event, she wrote an amicus brief in the Windsor case for family law professors. Each speaker is going to speak for about 10 or 12 minutes, and then afterwards we'll open the floor up for questions. Professor Somin.
So I'd like to start by thanking the Chicago-Kent Law School and all the different sponsoring organizations for organizing this event, and all of you for attending. Obviously, the recent Supreme Court same-sex marriage decisions raise many different issues. Among others, the Windsor case raises important questions of federalism. I was actually a co-author of a brief by a number of legal academics arguing the Defense of Marriage Act goes beyond Congress's powers and therefore intrudes in areas generally left to the states. This rationale played some role, perhaps, in Justice Kennedy's opinion in the case. It's what enabled him to strike down DOMA without striking down gay marriage bans at the state level. So there's that issue. There's many other questions, but the one that I was asked to speak about specifically was a question that Justice Scalia asked in oral argument in the California Proposition 8 case, where he asked Ted Olson, if gay marriage bans are unconstitutional, when did they start to be unconstitutional? Was it in 1868 when the 14th Amendment was enacted? Was it in 1791 when the Bill of Rights was enacted? Was it at some other date? I think Scalia's point was that if it was not unconstitutional in 1868 or in 1791, then how could it possibly be unconstitutional today? And of course, most people in 1868 would surely have said that there's nothing constitutionally wrong with limiting marriage to opposite-sex couples. So it's probably easy to answer Scalia's question if you're a living constitution theorist, if you're not an originalist. The whole point of living constitution theory is that the meaning of the Constitution can change over time, so even if it meant one thing in 1868, it could very easily mean something different in 2013. It's perhaps a little bit harder to give an answer from an originalist point of view to his question, but I think not as hard as Justice Scalia might have thought that it was, and that's what I'm going to talk about today. So I'm going to suggest that there is, in fact, an originalist argument for ruling that laws banning same-sex marriage are unconstitutional once you recognize two things. First, that laws banning same-sex marriage, they're actually discriminating on the basis of gender much more than on the basis of sexual orientation. Second, if you recognize, as actually Scalia and most originalists do, that originalism does require some adjustment to changing circumstances, the original meaning of the principles of the Constitution may not change, but how they apply to particular cases necessarily depends on facts, and some of those facts are ones that were not and could not be known in 1868, but rather only become known at the time that the court hears a particular case. Any kind of legal interpretation necessarily involves the application of general principles to specific facts. That's what it means to hear a case, and originalist interpretation is no exception to that. So let's first look at the 14th Amendment and sex discrimination. At the time the amendment was enacted in 1868, it's certainly true that most people readily accepted lots of forms of sex discrimination that we today would say are wrong or unconstitutional. However, there was a general recognition that sex discrimination was in fact constrained by the amendment, at least to some degree. There was litigation about the subject right from the start in the early 1870s. Most forms of sex discrimination then on the books were upheld by the courts, and that was true for many decades, but they were not upheld on the basis that the 14th Amendment just didn't restrict sex discrimination at all, but rather on the basis that those particular laws did not unduly oppress women or discriminate against them in a way that made them second-class citizens in an unjustified manner. Rather, the courts, as well as most of the rest of society, believed that those kinds of discrimination were justified because they were based on real and genuine differences between the sexes, as understood even by most scientists and experts at the time. Of course, over time, that viewpoint changed as we began to know much more than we did in the 1870s about the actual capabilities of women and their role in society. So many forms of sex discrimination that seemed justifiable based on factual understandings in the 1860s and 70s did not seem so 50 or 100 or 150 years later. And I think, but it's important to recognize that even right from the start, there was an understanding that sex discrimination was something to which the amendment did apply. If you're interested in this subject, there's a great article in the Texas Law Review that was published a year or two ago by Steve Calabresi and Julia Rickard, where they go into in great detail about the understanding of these matters at the time the amendment was enacted. This contrasts with the total lack of focus in the 1860s on the question of discrimination based on sexual orientation. Indeed, at that time and for many years thereafter, most people didn't even understand or recognize that there was such a thing as same-sex sexual orientation, in the sense of people who by their nature are attracted to those of the same sex rather than the opposite sex. The dominant view was that same-sex sexual relations were just a sort of temptation that actually heterosexual people would occasionally fall into. It was a kind of sin, but it was not seen as a separate and distinct kind of sexual orientation, and so people didn't even think in terms of discrimination on the basis of sexual orientation, much less recognize it as a category that the 14th Amendment might have something to say about. So what is the relevance of all of this to same-sex marriage? Well, the relevance is that laws banning same-sex marriage, in fact, discriminate on the basis of gender much more than sexual orientation. Those laws, in fact, do not restrict who can get married based on what your orientation is. It's perfectly legal for people who are gay or lesbian to enter into opposite-sex marriages, and of course, such things have happened. A famous case a few years ago was James McGreevey, the then governor of New Jersey, who it turned out was a gay man who was married to a woman for many years. What he did may have been unwise, but it was not in any way, shape, or form illegal. On the other hand, laws banning same-sex marriage clearly do discriminate on the basis of sex. Who you are allowed to marry is entirely dependent on what your gender is. Think of three hypothetical people, Anne, Bob, and Charles. The only thing in which they differ on is that Anne is a woman and the other two are male, but they're the same in every other conceivable relevant respect. Anne is allowed to marry Bob if they want to, but Charles is not allowed to marry Bob, and the only difference between Charles and Anne in this scenario is that one is a man and the other is a woman. That is the very essence of sex discrimination, a situation where your legal rights are dependent on whether you're a man or a woman, on your gender. And that's exactly how these laws work. Now, some people say, well, it's not really sex discrimination because the laws aren't motivated by hostility to a particular gender. They may be motivated by hostility to gays and lesbians, but not to men or women as such. However, with sex discrimination, as with race discrimination, the court has said, I think correctly, that you can have sex discrimination when your legal rights depend on what your gender is, even if the motivation for the law is not hostility to a particular sex. So the 1976 case of Craig versus Boren, the first case where the Supreme Court said that sex discrimination gets a heightened level of scrutiny, it in fact involved an Oklahoma law which forbade the sale of certain kinds of alcoholic beverages to 18 to 20-year-old men, but not to 18 to 20-year-old women. Nobody contends that this law was the result of some deep hatred of men on the part of the Oklahoma state legislature in the 1970s, but it nonetheless clearly was sex discrimination, and the Supreme Court ruled as such, and I think the same applies to laws banning same-sex marriage. Now, if you agree that there's sex discrimination, it doesn't by itself prove that they must be invalidated. The Supreme Court has said, and the original meaning I think supports this, that one can uphold certain laws that discriminate on the basis of gender if those laws meet a certain kind of heightened scrutiny. The way the Supreme Court puts it is they say it must be substantially related to an important state interest. I don't have time right now to go through all the different state interests that people have asserted in defense of these kinds of bans, but I do not believe that any of those interests can pass heightened scrutiny, and we can talk about that in the questions. I recognize that that's a controversial claim that not everyone would agree with. I think they can pass a very minimal scrutiny, a so-called rational basis, but not a heightened scrutiny. So returning to the question of originalism, I think all of this goes to the general point that originalism, like other theories of constitutional interpretation, involves the application of principles which themselves may not change to factual circumstances and knowledge which necessarily do change, and most originalists, including Justice Scalia, recognize this. So, for instance, in the Kylo case about a decade ago, Justice Scalia voted to contend that the use of infrared imaging can be a search that violates the Fourth Amendment. Obviously, this technology did not exist in the 1790s, but Justice Scalia had no problem applying the principles of the Fourth Amendment to a factual circumstance that did not exist in the 1790s and could not even have been imagined at that point. Similarly, just a couple years ago, he voted, I think correctly, to strike down a California law that restricted minors' access to so-called violent video games based on the First Amendment. Obviously, there were no video games, violent or otherwise, in the 1790s. People could not even imagine perhaps such thing as video games, but the principle of the First Amendment, as understood at the time, was certainly broad enough to cover this situation. Similarly, at the time the 14th Amendment was enacted, many people, including scientists, believed in the validity of phrenology, which was a pseudoscience which held that if you feel somebody's skull and determine the shape of it, that tells you useful and important information about their personality and character. If somebody had been convicted of a crime based on phrenological evidence in the 1860s or 70s, a court might well have upheld that based on the scientific knowledge available at the time. Today, we would surely strike down that conviction because we know that phrenology is a fraud. What's the relevance of all this to same-sex marriage? Well, I think in the 1860s and for many years thereafter, it was inconceivable to most people, including most experts on social science and the like, that same-sex relationships could serve the same social functions as opposite-sex marriage, such as caring for children, promoting social stability, creating bonds of love and commitment, and so on. But today, we do have a lot better evidence, and it's pretty clear that they can do these things probably just as well as opposite-sex marriage, but even if not as well, certainly well enough that it serves a social purpose to recognize these marriages. You can say, well, when exactly did we find this out? Was it 1970, 1980, 1990? I think if pressed, I would say it was sometime in the last 3 or 4 decades. But for a court deciding these issues, it actually doesn't matter exactly when the relevant facts became known. What matters is, what are the relevant facts as they are available at the time the court is making a decision in 2013 or in some later year. If the evidence in 2013 is such that this kind of sex discrimination cannot pass the scrutiny appropriate under the principles of the original meaning, then I think the consistent originalist has to strike down the law, and he or she has to do that even if they can't pinpoint the exact date at which the relevant facts first became clearly known and understood. So on that note, I conclude, but I very much look forward to the discussion and questions. Thank you.
So my job is to talk about a different approach to thinking about the Constitution, and I don't disagree with an awful lot of what Professor Somin had to say. I think that, in fact, what courts often try to do in the context of constitutional law is apply principles which they believe have been are consistent with what the framers had in mind to new situations and new facts. But I think it can be very difficult to actually know how to define those principles if you just look back to what the framers were thinking in 1791, 1789, or 1868. And so I think it's also useful to think about other approaches to the constitutional law and constitutional interpretation that allow us to take into account not just changed facts and changed knowledge, but changed understandings that are maybe more value-laden than simple scientific facts. I'm going to just start by saying a few words about the sort of pure form of originalism, which is not, I don't think, what Professor Somin has been defending, but is sort of what's implied by Justice Scalia's question, that we have to ask, what would the framers have said about this problem? And of course, I don't think anybody would dispute that the framers of either the 14th Amendment or the Bill of Rights would have said, what? If you had asked them if there's a constitutional right to same-sex marriage. I think that's pretty uncontroversial. The problem with this question is that it doesn't always really work very well. Professor Somin gave you the example of the thermal imaging case. I want to give you an example from last term involving GPS devices. GPS devices put on somebody's car. The question is that an illegal search or seizure? Or is it a search or seizure at all? And if it is, then it would be subjected to this whole array of Fourth Amendment protections. And the court concluded 9-0 that, in fact, the Fourth Amendment does apply to attaching a GPS device to somebody's car, but they disagreed about reasoning. And the justices who concurred in the judgment made a little bit of fun of Justice Scalia's majority opinion, in which he talked about this being comparable to a constable hiding in somebody's coach to see where they went. And the people who concurred in the judgment, I believe it was Justice Alito who wrote the opinion, said, boy, that would be a very tiny constable, right? And a very patient one as well. So sometimes this attempt can actually look even a little bit silly. And in fact, as a practical matter, there aren't really very many, if any, true originalists, people who are really willing to always say, well, what would the framers have said about this question? And this came up even in the oral argument in the same-sex marriage cases, where Ted Olson, when he was asked this question by Justice Scalia, actually seemed somewhat taken aback by it, which I found surprising because it wasn't a surprising question. But he responded with a question, and he said, well, when did it become unconstitutional for states to outlaw interracial marriage? And Justice Scalia said, well, that's easy, 1868. Well, I think if you'd asked the framers of the 14th Amendment in 1868, they would disagree with Justice Scalia. The anti-miscegenation laws were on the books at the time and for about 100 years afterwards, before the Supreme Court finally said that they were unconstitutional. So what's the alternative? I'm going to talk about the living constitutionalism, which is, as Professor Somin said, often seen as the alternative to originalism. And it's a term that's actually only recently started to be reclaimed by people who support this view. For a long time, it was really a term that was largely used derisively. And it was largely used derisively because people allege, and there's something to these allegations, that if you're willing to say that the Constitution lives and changes and evolves, then you're willing to say that judges can make stuff up. And that there is, what they're doing is imposing their own worldview, they're legislating from the bench, they're activists, you've all heard these phrases over the years. And what we're worried about are judges gone wild. So I'm going to argue that it doesn't actually necessarily mean that, and in fact, historically, it basically hasn't meant that. The first thing I'm going to argue, though, is that, in fact, there's a sort of an underlying premise to the sort of pure originalist approach, which I think is a couple of underlying premises that I think are not accurate. The first is the notion, I think, that there is a right answer that we can find in the Constitution to certain difficult questions. We can find in the Constitution and we can find in the writings of the framers and the thinkings of the framers, if we just look hard enough, we'll be able to discern this right answer. And that, I think the Constitution is not written in those terms. The Constitution is written in much broader terms, and because it's written in much broader terms, it requires judges to apply a certain amount of judgment, subjectivity, to bring to bear their own perspectives on what the words of the Constitution means. To give you an example outside of the same-sex marriage context, a few years ago, the court held in a case called Parents Involved that school districts, public school districts, could not make race-conscious assignments of students, right, decide we're going to say students of a certain race we're going to ask you to go to this school as opposed to this school in order to promote integration, right? This was not a situation where school districts were trying to have segregated schools. It was the opposite. The school districts in question were trying to have integrated schools, and they didn't rely on race entirely. In fact, it was a relatively small part of their decision-making process, but sometimes they said, no, you're going to have to go to a different school because we want to maintain some basic racial balance in our schools. Well, if you read the Equal Protection Clause of the Constitution, it doesn't say anything whatsoever about this. It says, right, the equal protection of law shall be enjoyed by the citizens. It doesn't tell us what that means in the context of a school district trying to achieve integration. In order to decide what it means, the justices had to bring to bear their own understanding of what equal protection means. And so the justices in the majority in that case, or the plurality, believed that equal protection means that there can be no race consciousness in the law, that that's what it means. Whereas the justices in the dissent argued that no, equal protection allows us to take into account the effects of a law. And if the effects of the law are to promote equality and to promote a situation in which ultimately we'll have a more integrated and equal society, then that's a legitimate use of the law and is not outlawed by the Equal Protection Clause. A second argument that I think is worth pointing out is an argument about what the framers themselves intended. Originalists sometimes claim that this is what the framers wanted, right? They passed these laws, they wrote the Constitution, it was ratified. What people wanted at the time was to have it be sort of written in stone and for us to interpret it in those terms. It's not clear that that's what the framers had in mind. As Justice Kennedy said just the other day, I don't think Madison and Wilson and the members of the drafting committee spent a lot of time with the dictionary. I think they wrote in expansive terms, life, liberty, property. You have to recognize that if the framers knew all the specifics of a just society, they would have written them down. They didn't do that. So that's Justice Kennedy arguing that we can't assume the framers had the answers. They did not. I'm going to end by talking about the objection to the living Constitution that I'm going to, that I already mentioned, the judges gone wild objection. And the argument is that, in fact, judges are not completely unconstrained in what they do if they interpret the Constitution in the sort of general manner that I'm describing. And there are two major reasons for this. One is that they actually, in order to write an opinion, have to articulate the reasons why they think that the Constitution should mean what it does. In other words, they have to be explicit about the values or the perspective that they're bringing to bear. Justice Breyer, for example, has written books about this in which he says, look, my view is that the Constitution should be interpreted so as to promote democratic participation. And that's the value I'm going to bring to bear when I have to decide a difficult case. And I'm telling you that, so you know. And he would say, originalists are doing the same thing, they're just not telling you. They're just not telling you what the value they're bringing to bear is. The second reason that living constitutionalism isn't necessarily totally unconstrained has to do with the common law system. We don't live in a world where each case is decided as if it were in a vacuum. It's not. Each case is decided on the basis of a long line of precedent. And the justices, generally speaking, can't move too far from the last precedent without having a very good reason. Common law method has been around for hundreds of years. It certainly predates the Constitution. And in fact, as Professor David Strauss at the University of Chicago has pointed out, it is undoubtedly and really indisputably what the Supreme Court does when it decides constitutional cases. If you go look at the briefs that are filed in the Supreme Court in these difficult constitutional cases, there's an awful lot of case law. Right? There may be some information about the framers and their intent and what was going on at the time, but there is more than anything going to be case law. Because that's what the justices are going to be looking to. What have the cases said before? How is this new case meaningfully similar or different from how those cases have gone before? And how, when I bring to bear the relevant value of, for example, democratic participation. How does that all fit together? In the same-sex marriage cases, arguably that is in large part what we saw happening, and I think you can say that even if you don't buy the argument that that bans on same-sex marriage are intrinsically the same as are intrinsically sex discrimination. You can look to a large body of law that has evolved under the Equal Protection Clause that identifies the types of reasons why it's okay for government to distinguish between groups of people. Generally speaking, the Equal Protection Clause says it's not okay for the government to distinguish between groups of people on the basis of the color of their skin. Generally speaking, it's not okay, although it's sometimes okay, but it's less okay, or it's often not okay to distinguish between groups of people on the basis of gender. The Supreme Court has also said, and this is in large part what the majority relied on in the Windsor case, that it's also not okay for Congress or for the government to distinguish between groups of people out of a bare desire to harm one of those groups of people. So to say, look, we just don't like you. We just think you're, as essentially the House did say in the context of DOMA, we think you're immoral. And we don't like you, and we want to keep you from having the same benefits of citizenship that everybody else has. The Supreme Court didn't make that up in the Windsor case. It relied on a long pre-existing line of cases. There's much to criticize about the majority opinion in Windsor. We may hear some of that, but it cannot be said that it did not rely on pre-existing case law. So thank you.
So as all my contract students in the audience know, I have been suffering from voice deprivation for 3 weeks, so I apologize if my voice is not as strong as it usually is. So I'm going to answer the question. The question that we were all asked to address was, when did same-sex marriage become a constitutional right? And I know I have the right answer because I heard it on NPR. And I heard it on NPR this summer when Margaret Mitchell was being interviewed by Nina Totenberg. And Margaret Mitchell is the former Chief Justice of the Massachusetts Supreme Judicial Court, and Margaret Mitchell was the author of the first opinion in this country that granted same-sex couples the constitutional right to marry. It was under the state constitution, but she said same-sex couples have a constitutional right to marry. So I want to preface this actually by saying I have tremendous respect for Justice Mitchell, and I probably would have signed on to the opinion if I had been a justice on the Massachusetts Supreme Judicial Court, but she said an incredibly silly thing on NPR. What she said was, well, marriage became a constitutional right when it became so important to people's lives. And what she meant by that was the way in which marriage today functions in our society as a portal to a huge number of social welfare benefits. It serves as the primary source of survivors' benefits, of old age benefits, of disability insurance, and of health insurance for very, very many people. Sorry, that's my name. So she's right that marriage functions this way in our culture. It actually functions this way in our culture in a way it doesn't in Western Europe. In Western Europe, many of those social welfare benefits get distributed directly from the state to individuals. In our country, that doesn't happen. Most access to those kinds of benefits, certainly the optimum form of those benefits, comes through marriage. But it was a very, very silly thing to say for two reasons. The first is that marriage cannot be more important to women's lives today than it was 150 years ago. 150 years ago, marriage was like the only source of wealth for women. It was the only source of any sort of future security, and it was the only way possible remotely for women to raise children in any sort of respectable manner. So it can't be that marriage is more important now than it was 150 years ago. Just as important, if marriage is just that bag of stuff, if marriage is just those benefits, then civil unions do the trick. Because civil unions, anyone who's in a civil union in Illinois today is entitled to every single social welfare benefit that a married straight person is entitled to. They just don't have the name marriage. So if marriage is a constitutional right, you need to think about what is marriage qua marriage, right? What is it about marriage that makes it a constitutional right? So I tried to answer that question sort of about 6 or 7 years ago I wrote this law review article. It's what we do. We law professors, we write law review articles. And I wrote this article in which I tried to explore the social meaning of marriage. And I suggested that marriage has both this expressive and constitutive function, that by getting married, what one does is one expresses something to oneself and to one's partner and to the community at large. A big part of what one expresses is that one is no longer solitary. One is part of a unit. One has responsibility for someone else, and that other person has responsibility for you. That kind of blending with another person is an important part of who you are. And the act of doing that actually reflects back on the person and does change who the person is, right? And so marriage is a big deal for those reasons. I mean, it's a kind of constitutional right that rings as much possibly in the First Amendment as anything else. I think it fits in fairly well with the Supreme Court jurisprudence on marriage, not so much Loving v. Virginia, which I think is a pure sort of race discrimination case, but you guys don't have to know these cases, but there's a case called Zablocki v. Redhale, which involved a very low-income man, and a case called Turner v. Safley, which involved a prisoner. And in both cases, the court said that those two people had a constitutional right to marry. Now, they had a right to marry, notwithstanding the fact that they weren't actually going to get any of those social welfare benefits for a whole variety of reasons. The court seemed to think those guys had a right to marry because of how important marriage was in people's lives, because of what it would mean to them to be able to get married. Okay? So I wrote this article, and I posted it on SSRN. That's also what we do. And nowhere in this article did I say anything about marriage being restricted to a man and a woman. And I got this response from the traditional marriage folks, from people that were opposed to same-sex marriage. And they loved this article, which made me a little nervous, but they loved this article. And they said, yeah, you're right. To this day, I'm on like these mailing lists of these people. It's funny. And they said, you're right, marriage is this symbolic thing, right? The reason marriage is so important to people is because of its symbol, because what it means, because how it allows people to become someone different. But, they said, what you're missing, idiot, is how marriage is this inherently gendered institution, how that constitutive aspect of marriage is about marriage reifying gender roles. And I was actually involved in correspondence with one of these guys who was a very smart, very responsible, very kind man. He was a former Justice Rehnquist clerk. And in correspondence, he actually used the phrase genderless marriage. And he used that phrase as an oxymoron. And that really struck me because I realized that he was thinking of genderless marriage as an oxymoron. And I, at that time, a wedding ring on my finger, was thinking of genderless marriage as the ideal, right? I wouldn't have entered into this institution if it was inherently gendered. But we were both using the term marriage, and we were meaning very different things, okay? So I actually looked into that. I did a bunch of reading, and I came to the conclusion that actually for many traditional marriage folks, it's not disdain for gay people or hatred of gay people. It is a really powerful belief in the importance and the positive benefits of gender roles in marriage. What marriage does for men is it takes these sort of slovenly, selfish, video game playing young people and turn them into responsible, caring, providing men. That's what it means to be a good husband. That's what it means to be a good father, right? For women everywhere, married or not, do a tremendous amount of unpaid labor. It's women who check in on the elderly people next door or the grandmother. It's women who take Aunt Flo to chemotherapy. It's women who do a tremendous amount of the unpaid labor of childcare. And married women actually get rewarded for that in ways that unmarried women don't. Married women get rewarded for that in part because they get some sort of financial support, usually from a spouse, but they also just get emotional support. Married women report feeling much better about all that unpaid work that they do because they feel supported. Because within marriage, what you're supposed to do, if you're being that good husband and good father, is make the person doing all the unpaid work feel better about it, okay? So these gender roles, right, not only serve individual interests, which might explain why married people are happier, healthier, wealthy than non-married people, which is true. I mean, it's documented at least. But they have tremendous social benefit, right? We've got all these community-minded men running around volunteering for doing stuff and being better citizens and being better workers than the unmarried men. And we have a bunch of women being perfectly willing to do all this grunt work that people have to do, but they don't feel so bad about doing all that grunt work. What a great institution. So the typical sort of liberal response to that is, look, that's just an outdated view of marriage. Like, marriage doesn't work that way anymore, and besides, right, that violates all sorts of legal norms of gender equality. So it does violate a whole bunch of norms of legal norms of gender equality. Here's what it doesn't violate: the norms by which most people today, straight couples, live their lives. Marriage today is still an incredible gender factory. That's not my term. It's actually a sociologist named Sarah Burke's term. But before people get married, you know, to sort of put it into anecdotes, before they get married, women take their car to the shop and men do their own laundry, and after they get married, they don't do that anymore, right? After people get married, the work that they do within the household, the work that they do with in their own private time becomes incredibly gendered in terms of how they actually spend their hours, right? So 64% of paid work in any marriage gets done by a man, 67% of the unpaid work gets done by the women, okay? When people get married, all these numbers are in stark contrast to cohabitation, by the way. People don't fall into these gender roles when they just live together. They fall into these gender roles and they start living these gendered lives once they get married, okay? They don't say they do this. They don't say they believe in this. In fact, if you ask people whether they believe in gender egalitarianism and they believe that work within the family should be equally divided between men and women, they say yes, right? But they don't do it. In fact, there's a really cool sort of correlation, curious correlation. So educated people are much more likely to espouse belief in gender egalitarianism, right? So education associated with equality, egalitarianism. Education also correlated with wealth, right? Wealthy people more likely to be well educated. Wealth correlated with highly gendered marriages. The more they can afford it, the more people fall into the traditional gender roles, okay? So what's all this have to do with gay people getting married? Here's the problem, and what the anti-same-sex marriage people would say. What they would say is, what's going to happen to your gender roles? You got two slovenly video game playing guys together. Who's going to step up, right? Who's going to be the one who takes the responsibility? You have two women running around doing all this unpaid labor and no one feels respected, or no one does the unpaid labor. What's going to happen to those gender roles, right? You're putting those at risk if you start taking away this core historical reason for people getting married, okay? If, as historically understood and as contemporaneously practiced, marriage is an inherently gendered institution, then gays and lesbians don't have a constitutional right to it, any more than Professor Heyman has a right to terminate a pregnancy after 3 months, within the first 3 months. I have that right? But it's meaningless to give it to him because he can't use it. If marriage is an inherently gendered institution, then it doesn't make any sense to say that gays and lesbians have it. Okay, so if I just said that, why did I say I would have signed on to Margaret Mitchell's opinion? Margaret Mitchell wrote Gone with the Wind. Margaret Marshall's opinion. Because I actually think there's I think there's a huge amount of social dissension around this. I think that judges in states like Massachusetts and California and those, crazy progressives in Iowa that people on the coast always forget about, I think that they can actually look at their populations and say with a straight face, I think people in this community, I think people in our state, I think they believe in an aspirational view of marriage that is ungendered. They believe in genderless marriage as an ideal, and even if they aren't living it, they think that that's the best way of describing what marriage means to them. But there are plenty of Supreme Courts in other states where that would be a completely disingenuous thing to say, right? Where they actually don't think people within their states feel that way. And the advantage that the other side has is reality, right? take a look around the next wedding you go to, right? Where you got all the girls lined up in one color on one side and all the boys lined up in another color on the other side, and tell me it's not something but one big celebration of gender complementarity, right? And if that's what people are celebrating when they get married, and that's what people really think about when they get married, then it's very difficult to say that there's a federal constitutional right to marriage right now. Okay, I'm done.
Okay, at this point, we'd like to open the floor up for any questions or comments that people have.
Question. Steve?
Yep.
I want to ask you about gendered roles within same-sex couples, because that Edith Windsor profile talked a lot about that specific thing, which for people that didn't see it, her spouse wanted to be called a spouse and not a wife, and got upset that she couldn't carry in, the groceries when she got old. So I wonder, how does that fit in?
Right, so one, perfectly obvious critique of what I said is, well, you're just talking about gender, you're not talking about sex, and same-sex couples can be just as gendered as straight couples can. And I think that that's true. I think, I'm a nerd, so I know, all the studies that have been done, and while same-sex couples do tend to be somewhat gendered, they don't tend to be nearly as gendered as straight couples. But more to the point, I think that the people who really believe in the validity of gender roles would say, yeah, but whatever they do, what makes marriage work so well for straight people is if you're biologically female, you know what your gender role is supposed to be when you get married, and you're biologically male, you know what your gender role is supposed to be, and those gay people can do what they want. But, we want these things clear because that's the best way to, maximize the complementarity of marriage.
Seth.
I'm curious how you feel. All this talk about marriage having this sort of traditional cultural connotation of being inherently gendered. Is that maybe an argument in favor of conferring same-sex relationships the right to a civil union or a civil domestic partnership, as opposed to marriage? Does letting them into the general pool of marriage then force these relationships maybe into a gender role structure that they don't necessarily fit? Is marriage the right framework to move towards?
Well, yeah, I think so, because I'm actually a kind of believer in marriage. I think the problem with civil unions is that they actually think of marriage just the way that Margaret Marshall did, as just this bag of stuff, and I don't think that's actually marriage's primary value. I think marriage's primary value is its symbolic effect, and I think that gays and lesbians should have every much a right to try and tap into that as anyone else.
I think also there are gay rights activists who would say we don't want to get married, right? For exactly that reason. Marriage has not exactly been a progressive institution, they would say. We want to create something new and different.
Just a quick thought on this. I think the big flaw in this kind of argument from a constitutional point of view, even if it gets all of the empirics exactly correct, which I'm going to dispute in a moment, but even if its empirical analysis is completely right, there are lots of statistical generalizations about the genders and also about racial groups which may be completely accurate, but which cannot justify the government discriminating on that basis. For instance, on average, the data strongly suggests blacks are much better on average at basketball than whites are. That would not justify a state law forbidding or even restricting whites in some way from playing basketball, because it's still unconstitutional for a government to use even accurate statistical generalizations, often for purpose of discrimination. And the same thing applies to gender discrimination as well, especially in a situation like this where, yes, obviously, statistically speaking, the majority of marriages have this gendered aspect, but there's tremendous variation. The numbers you gave are 64% and 67% of one type of work being done by one gender, another type by the other, but 64% is a lot less than 90 or 100%, and that conceals enormous variation. Moreover, the data on the way marriage has evolved over time, compiled by economists Justin Wolfers and Betsy Stevenson of the University of Pennsylvania shows that over time, there's actually much less strong division of labor within marriages than there used to be, in that to a much larger extent than in the past, people are getting married to those who are like themselves in terms of education and interests, as opposed to those who are very different and will fulfill different roles in the household. There are various economic and social reasons why this has happened, but we're actually, especially in the middle and upper classes, moving away from a very strict and traditional division of labor based on gender within marriage. So even empirically, this generalization isn't entirely correct, and it's getting less correct all the time. But even if it was completely correct, it's still a statistical generalization with many exceptions of exactly the same kind that the court, and incorrectly, has said we're not allowed to use as a justification for racial or gender discrimination in the law.
Can I respond to that? First of all, I think the notion of equality in gender is just infinitely more capacious than the notion of equality in race. And, you know, if you look at, you know, the Rotzker, if you look at the draft case, the opinion basically said, well, if Congress really knew what it was doing and meant to discriminate on the basis of sex, then it can. That was a case that said men have to register for the draft and not women, right? I mean,
They got that one wrong.
well, okay. But I think, you know, right, separate is not equal with gender? Absolutely not the case, right? VMI, the Virginia Military Institute case, does not read like Brown v. Board of Education does. VMI, they actually go through and say, is this the same? Right? Is this the same? Is this the same? Is this equal? They import a substantive understanding of equality that the court does not do in race. I think for very good reason. I think the reason they do that, right, is they didn't want to say, yes, your barracks have to be integrated. Yes, Sharon Faulkner has to cut her hair in a crew cut the way everybody else at the Citadel does. There are lots and lots of social norms regarding gender that the court is unwilling to dismantle in the name of equality. I don't know how I feel about that. I don't really care whether they dismantle a bunch of those norms. I get called a man all the time on the weekends when I'm wearing blue jeans and a t-shirt, and I don't really care, but it upsets the hell out of everyone who calls me a man. It really, really bothers them. And I think that what that taps into is, right, a deep desire for something, for a society that is gendered, right? Now, as Todd pointed out, gay people can be just as gendered as straight people. But I think it's just fallacious to think that, particularly with the statistical arguments that haven't worked in race, that they will work, that they necessarily work in gender. With regard to how marriages are becoming less gendered, I completely agree. I totally think we're on a trajectory towards gay marriage, and I totally think we're on a trajectory towards less gendered unions. But if the question is when, I think part of the question is, when do we reach that tipping point? When do we reach that tipping point where marriages are ungendered enough that we don't think of it as an inherently gendered institution? And, you know, I'd love to say we're there, because I think we should be there. But I look around, and it's not clear to me that we're there.
So we're talking about gender as a traditional norm and something that's historical and cultural. So I guess I would like to know, is that something, a role that the state should be intruding on at all? So should we convey marriage in this sense from a governmental standpoint, or should we only convert and convey rights and send the bag of stuff from the state perspective? I think that is.
So I would say ideally, I don't think this is required by the Constitution, but ideally I would want the state to get out of the business of defining marriage, so that marriage would be an institution that's still an extremely important institution, but one that's defined by culture, private individuals and norms, religious organizations, and so forth. I do think, though, that if the state is in the business of defining marriage, and it is, and at least for a long time to come probably will be, then it should do so in a way that does not discriminate on the basis of gender or race or some of these other prohibited characteristics. And I think it's a little bit, I'm not sure this is actually your belief, but I think it's a little bit fallacious to say, well, either we have a marriage policy by the government that discriminates on the basis of genders, or we're committed to the idea that the genders must be exactly the same and there can't be any distinctions between them. There are lots of socially relevant and even beneficial distinctions that can and should exist, but the government should not discriminate on the basis of. So when we say the government should not discriminate on the basis of race, we're not saying that blacks and whites should be identical in every way and there should be no differences between them. We're just saying those differences should not be used as a basis for government discrimination, perhaps except in a few unusual instances. And I think the same thing with gender. I agree with gender. There may be a wider category of places where the government could distinguish, but it's still the case that there are many perfectly fine, or at least not terrible, distinctions on the basis of gender that can exist in society, but which should not be used as the basis of discrimination by the government. And marriage, I think, is one of those instances. So we don't have to say, well, all men and women are exactly the same.
But if we just sort of got rid of marriage altogether, or just left it up to sort of social institutions, you know, religion in American society, certainly in most Western societies, isn't up to the task, right? It's just not a formidable enough force. And so then what happens to it, right? And yeah, I mean, so I'm a kind of defender of the institution. I think that's maybe a sad thing.
Mohini?
I have a question, because I was thinking of it when we were talking about the Windsor case where they went to Ontario and then came back, and kind of the status of their marriage when they came back. I was thinking of, what if your sex changes and you haven't gone anywhere? Author Ilya Sohn was married before she transitioned. Did the status of her marriage then change once her genitalia did? Like, are there any cases that address that issue?
Most of the cases actually having to do with transgenderism have everything to do with marriage and invalidating marriage, because it's the one place where gender specificity is clearly allowed still by the government in many places. It depends what state she was married in before they legalized same-sex marriage. There are cases out of Texas and the like that have the cases go both ways. There are cases out of Texas and the like that say the marriage is invalid because now it's a boy married to a boy, and there are cases that say it was at the time of celebration and it was valid then, so it's valid now.
Sir?
The analysis is focused on two individuals, so it's the concept of marriage. The analysis changed off. If you look at marriage, it's not simply an institution between two individuals, but a family unit, where the traditional goal is not only the union, but also procreation.
So this is one of the arguments that's made by defenders of bans on same-sex marriage, to say, well, this is a state interest that exists in the case of opposite-sex marriage, but not same-sex marriage. I think that argument is false for several different reasons. One is that, in fact, we allow many opposite-sex marriages to occur even though the people either biologically can't procreate, or it's pretty obvious that they're not going to, in the case of people who are infertile, or an example that Justice Kagan used in the oral argument, what if somebody's married and is over the age of 80? And you can say, well, those people, they can adopt. So they can, in effect, if not procreate, but raise children, even though they can't have biological children. Of course, the same thing is true of gay couples. In fact, in California, even before they had same-sex marriage, gay couples could adopt. In addition, some lesbians have biological children through artificial insemination and the like. Some gay men, like McGreevy, who I mentioned earlier, had children by women early in their lives. So I think same-sex relationships are capable of raising children and clearly do raise children, unless you define procreation very narrowly as simply biological procreation with your particular partner. And if that's the case, then numerous opposite-sex marriages also would not qualify. And we have never, I think even in the entire history of Western civilization, taken the position that the law will only recognize marriages where biological procreation between the two partners is possible. That's never been the law, never been the social norm either.
There's also, I think, even if you take as at least a partial given, and I think I do take as a partial given that raising children is an important, and creating a family is something important that happens in marriage. It doesn't strike, and leaving aside the argument that Professor Somin just made, that in fact there are lots of same-sex couples raising children, even if you think that raising children is this important piece of marriage, that's what the institution is about. I don't see that as a reason to exclude same-sex couples from marriage. It's a reason to have marriage, perhaps, but it doesn't seem to me to be a justification for saying, you guys get it and you guys don't.
There are two arguments I think that are important to distinguish. One is marriage is the place for making babies, and the other is marriage is the place for raising babies. The procreation itself argument actually, I think, doesn't go very far because procreation has happened outside of marriage forever. And actually, if you look at the traditional marital presumption, which is that the husband of the mother is the father of the child, and Blackstone actually said with regard to that, the reason for marriage is for raising children, not having them, raising them. So what the marital presumption did was ensure that a child had both a mother and a father. We were completely incapable of figuring out whether the father was biologically related, but that was the purpose of marriage, was to have two parents. I think the answer to your question actually is a question of the burden of proof, because assuming that part of the important social meaning of marriage is raising children, the question is, can the legislature, can the government say, well, straight parents are, the ideal is biological parents, and we are going to prefer biological people who can have their own biological children over same-sex couples. Okay, the adoption argument actually doesn't really go very far because everybody who adopts a child has to basically get a license to parent first, and we don't apply that in marriage, right? Your kid gets to be your kid without a license to apply for parenting if your kid is born into your marriage. The reason it's I think, a burden of proof question is if marriage is some sort of fundamental right or if there's some sort of equality right to marriage, then the burden shifts to the state to say biological parents really are better at raising children, right? And if there's no constitutional right, then this legislature just kind of gets to do whatever it wants under rational basis review, right? There's the one thing we know, it's incredibly difficult to get reliable child raising studies because they have to be longitudinal and it's just impossible to get the right kind of data. The one thing that seems to have emerged to date is that children born into married biological families are more likely to do better than alternatives, right? Step parents don't make any difference. Step parents do no better than single parents, right? There's this weird data suggesting, weird to me because it sort of upsets what I would like to think, right? There's this weird data suggesting that the presence of the biological father seems to be more important than the presence of the biological mother. There's weird data out there, none of it definitive, right? Which is why burden of proof matters, because neither side can prove that gay people are just as good or that straight people are better, right? So it's all a question of who has the burden.
I'm not sure that framing fully works because let's say it's definitively proven that kids raised by their biological parents in heterosexual marriages, the parents are in those marriages, that's the best possible alternative by far, by a huge margin. First, virtually all children that are actually ever likely to be raised by gay parents are not ones where that is actually a realistic alternative. Either they're people whose biological parents put them up for adoption, or they're biological children that the gay parents themselves had through artificial insemination and the like, and obviously those children themselves almost by definition could not have been created through heterosexual marriages. So for the children for which this is actually relevant, we're talking about an alternative that may be hypothetically better, but it's kind of like saying, well, if I had pie in the sky and it really existed, that would be better, but it doesn't actually exist. The other point to remember here is that when we're talking about burdens of proof, the relevant question is the state using a form of classification, in this case I would say gender, where they're required to pass some kind of strong test before they can use it? And if the answer is yes, that there is that kind of classification, it's surely not enough to say that there's this hypothetical relationship that doesn't actually in any real way apply to the people we're actually talking about that would be better. That's I think makes very little sense, that sort of argument. So even if those studies definitively prove that on average biological parents are clearly superior to all other kinds of family arrangements. That's just not relevant to the families and people that we're actually talking about in these cases.
The only thing that ignores is the way in which most people have talked about marriage for years is serving a channeling function. So the idea of restricting marriage to straight couples is the whole purpose of having marriage is to channel people into these roles. And I think it's just fallacious to say that gay people will have children anyway. I don't know. This is actually a really hard historical change question. Like, maybe the door has been opened so that gay people will never go back, right? McGreevy would never do it again. Gay people will never go back and marry people in order to have children. But I know, like, lots of people from my parents' generation who didn't come out until their 60s or 70s. They'd raised children, right? And a bunch of conservative people would say, yep, that's fine, that's the way it should be. What they did is they got married and they had their kids and they did the right thing. And then, you know, what they do when they're 60 and 70, who really cares, right? But marriage at that time, you know, peak conservative 1950s time, channeled people into this institution, and everybody got married and everybody had children, and the data would suggest that maybe the kids are better off. We have no real data on gay parenting is the problem, and we're unlikely to get it in a reliable way anytime in the future.
I'd like to ask the panelists about the implications of Windsor for the ongoing litigation in other states about the constitutionality of refusing to recognize same-sex marriage. So, I mean, that was the issue that the Supreme Court punted on in the Proposition 8 case. The court declined to decide whether there was a federal constitutional right for same-sex marriage. In Windsor, Justice Kennedy, in his majority opinion, said we're just not addressing that here. And there's kind of an interesting, byplay between Roberts and Scalia, where Roberts wants to underline the fact that the majority doesn't hold that there's a right to same-sex marriage, and Scalia says, don't you believe it? Windsor has already effectively decided the issue. He quotes various passages from Justice Kennedy's opinion, where Kennedy talks about how Proposition 8 was denying the dignity and equality and liberty of gay people in the case of relationships that were recognized. And then Scalia goes through and says, I can write the next opinion right here, and just substitute, these various words to show that Windsor really has already effectively decided that there is a federal right to same-sex marriage. So I'd like to ask the panelists what their view is of the doctrinal or conceptual implications of Windsor for this issue, and also ask them maybe to give us a little bit of a prediction about how long it's going to take the Supreme Court to revisit the issue and what you think it will do when it does.
So I think Windsor doesn't definitively by any means resolve the question of whether states can ban same-sex marriage, but it does strengthen the hand of those who are arguing that is in fact the case. Windsor has two components. One is the one you mentioned in your introductory talk when you said that it rules in part on the basis that DOMA undermines the liberty and equality rights of same-sex couples, and it particularly emphasizes that DOMA is motivated, at least in large part, by animus against gays and lesbians, and based on various previous decisions, such as Romer v. Evans in 1996, they said that a classification that's based on animus in this way is unconstitutional, or at the very least subject to a very high level of scrutiny. But at the same time, Windsor has a federalism component as well, in that Windsor says, again based on some previous precedent, that when you have a law that seems to discriminate, it will be subject to a higher level of scrutiny, and it will be an indication that the motive really is some kind of animus if what the legislature is doing is going outside of normal boundaries. And here it did that. Why? Because it's the federal government intruding into the question of the definition of marriage, which is normally left up to the states, and there's a lot of evidence that defining marriage, including influencing the states on the definition of marriage, was in fact Congress's objective here, rather than merely sort of some kind of bureaucratic definition of the scope of federal benefits. And because Congress was intruding into what is normally the state's territory, this is one reason, according to Kennedy's opinion, that what they did is subject to a higher level of scrutiny than perhaps it normally would be. This actually follows in some ways the analysis laid out in the brief that I co-signed with a number of other federalism scholars. They even cite us, woohoo, we got cited in the Supreme Court opinion. So obviously this federalism argument would not be available for people challenging gay marriage bans at the state level. However, much of the other analysis in Windsor does support them because it does emphasize that these kinds of laws are suspect if they're motivated by animus against gays and lesbians, and there is in fact a lot of evidence that laws banning gay marriage are motivated by animus. It's not the only motive behind those laws, but it's clearly a very important one, and I would argue actually that most of those laws, especially the amendments passed in the last few years, probably would never have been passed in the first place were it not for such animus. So Windsor, I think, helps the supporters of gay marriage, and more fundamentally, Windsor is part of a broader trend in both public and elite opinion, which is gaining speed very rapidly in terms of saying that gay marriage is something that should be accepted. So I predict that within 10 to 20 years, there will be a Supreme Court decision saying that laws banning gay marriage are unconstitutional. It may well not happen until after a majority of states already permit gay marriage. It may be similar to the trajectory of the courts with respect to interracial marriage, where by the time they struck it down in 1967, I think there were only about 16 states that still forbade interracial marriage. But I think that is the direction in which we're heading. If I had to guess, hard to predict the exact year, but I think we'll get there sometime in the next 10 to 20 years. It's possible it'll happen quicker than that, depending on who gets on the Supreme Court, and also depending on how fast the pace of the public and elite opinion is. Over the last few years, the pace of change in opinion has actually been faster than most people would have predicted, and if that faster pace continues, then things might happen more quickly than I currently expect.
I don't disagree with anything Professor Somin has said, except that there are already some very interesting cases percolating up involving the following scenario. A same-sex couple gets married in, say, Iowa, and then moves to where it's legal, and then moves to Arkansas. Does Arkansas have to recognize this marriage that was legal where celebrated? There is actually, I've noticed in reading in looking into this a little bit, constitutional law folks like me think, well, that violates the full faith and credit clause. And family law folks like Professor Baker say, no, it doesn't. It happens.
Or if it does, it's done so for centuries.
Right. It's always been the case that states don't have to recognize marriages that they've deemed illegal in their own states. Usually it's something like first cousins or such. So I don't know what will happen with those cases. I actually think it's going to be that's the next front. And depending on which way the courts sort of want to lean, it could sort of resolve the question of whether or not same-sex marriage is legal everywhere, sort of in this this sort of roundabout way, which many people are saying, well, that exactly is not what should not happen. Right? It should not happen that Arkansas has to recognize same-sex marriage because people get married in some other state that does recognize it. That in some ways is even more controversial, just as a kind of small d democratic matter, than the court ultimately holding that there is a constitutional right to same-sex marriage everywhere. I think the time frame, I would actually say the time frame is likely to be a little faster than 10 to 20 years. And I will just read you another quote from Justice Kennedy. This is just from the other day. He was talking about how fast the gay rights movement has moved, and he was talking about how surprising he found that. And he was talking about the court's role in this. He says, we come in too soon and too broad, and we terminate the democratic debate. On the other hand, he said, suppose you have a person with an injury, a person is hurting. He comes to the court seeking relief. The court could say, you go away for 10 years, then I'll see you. That would maybe be better for the court, but the individual might be denied his or her rights in the interim. So Justice Kennedy is kind of the swing vote on this question.
No, he's not, because he was the one who said they were standing in parity, right? The swing votes are Breyer and Kagan and Ginsburg, right? They're the ones who said no standing in parity. We're not going to decide this issue.
Oh, there are all kinds of reasons why they might have
Okay,
said that.
but I mean, I don't know anything. She knows 10 times more about how the Supreme Court works than I do. But
I know a lot less about family law.
It seemed, I thought if Kennedy had gotten parity, he would have said there was a constitutional right to marry in June. I think he wanted to do that. I think that it was Breyer and Kagan, and maybe I'm counting my people wrong, and Ginsburg, who said, no, we don't think we'll find standing there because we don't want to decide this until more states have come along themselves. Right? I mean, and the reason I would call them swing is they, for people who don't know that much about this like me, it didn't really make any sense to find standing in one case and not the other, and those were the three that found standing in Windsor and no standing in Perry, and everybody else actually lined up, except Thomas, for reasons that were completely incomprehensible. Everybody else lined up the same in both cases. So there's actually a recent case out of Ohio which did a typical thing, which doesn't really answer Professor Heyman's question at all, but it thinks it does, right? So it was a case of an Iowa couple who I think got married in New York, and they came back to Iowa, and they said, you have to respect our marriage, and Iowa said, no, we don't. And the court said, well, DOMA sort of decides this. Ohio. Yes, we do. What?
Ohio?
Yeah, sorry.
Iowa.
Sorry, yeah, no, not Iowa, Ohio. But the reason why it's not clear whether DOMA, and the district court said, you have to recognize this marriage, but the reason that it's not clear, as the district court kept on saying, is that Iowa's choice of law rules and marriage recognition rules have always been, we will recognize a marriage if it was valid in the place of celebration, right? Many other states have had different choice of law rules. So you could analyze that case as saying, well, what Windsor says is you can't treat gay marriages different than you treat underage marriages or cousin marriages or any of those things. But Illinois, for instance, has always had an incredibly strong policy of not recognizing, I could be getting my states wrong, but this is right, of not recognizing common law marriages in other states. Other states have very strong histories of recognizing a common law marriage as long as it was valid in another state, right? So politically, I don't think this is likely to happen, but if Illinois wanted to say no, for a long time, we've been actually very jealously guarding our own definition of marriage. Then I think it's much less clear how strong the opinion in Windsor is in forcing Illinois to accept those marriages.
Brief thought on this. There has been a lot of speculation saying, well, the justices' votes in the Proposition 8 case really weren't about what they thought about standing, but whether they thought they wanted to hear the gay marriage question right now. I think that could be true, but notice that there's weird ideological alignments of the justices on both sides of the case. They're both conservatives, liberals on both sides, which suggests to me that it doesn't seem like there's sort of a clear lineup with, say, conservatives wanting to hear this case and liberals not wanting, or vice versa. It may even be that they voted based on what they actually think about the standing issues. As surprising as that may seem, even if that's not the case, it doesn't necessarily follow that that because Justice Kennedy wanted to hear that case, he necessarily would have said same-sex marriage is a constitutional right everywhere. Remember, there were several other narrower options that he could have adopted here. For instance, he could have adopted the so-called 9-state solution, which says that if you have a civil union law which gives same-sex couples all the same substantive legal rights as opposite sex, then it makes no rational sense anymore to deny them the word marriage because there doesn't seem to be any real estate interest that's served by that. But that might be different in many states, which is still the majority of states, where it's not just that they don't have the word marriage, but they don't have many of the legal rights attached to marriage available to them either. There are also other options available, so it's possible that Justice Kennedy would have voted to strike down California Proposition 8, but without saying that there's a nationwide law or a nationwide requirement that gay marriage is a constitutional right.
I want to thank all three panelists for their very stimulating discussion of these issues. I want to thank you all again for coming. Please join us for the reception out in the lobby, and if you're interested, please go on up to the 3rd floor later on and take a look at the art exhibit. Ilya, that was just great. Thank you so much.
I just don't think, I just don't. I think
How much company do you have among the
but I
routines?